Good day and welcome to this week's edition of It's Chaile Time. I'm sitting here in the Pavilion Hotel in KwaZulu-Natal. We're having a large-scale retrenchment case that we are facilitating or having been facilitated by the CCMA. Okay, so this week we're also doing a case law review, and the question or the pain point, let me rather say a pain point for many employers that we are trying to address is with a recent case law that deals with employees signing a contract of employment whereby they agree to a certain notice period, in this case for 60 days. But you know, when you find alternative employment, then a lot of employees don't want to work the notice period. They sign with them or they resign with immediate effect. So can an employer compel an employee or force him to work notice period by maybe filing a dispute at the labor court for the act of a specific performance? And this is what this case law review wants to address today. Some very interesting points. This is a bit of a contentious issue, a lot of frustration for employers and also for employees. Remember, employees has a constitutional right to freedom of movement and to exercise and practice their trade, and sometimes you get that golden opportunity coming your way, but you are locked into a contract and you have to work a notice period, maybe 30 days or 60 days, sometimes even 90 days. So in this case, Bid Venture Consulting versus Karina Smith. This case came through the courts and was adjudicated and came out. The award came out on July this year, 2023. So Bid Venture basically is a software developing company, and they primarily focus in the financial sector. Now they obviously, employ a lot of white collar workers in terms of specialists, software developers, IT specialists, and so forth. Karina Smith, the employee, she resigned from her work on the 10th of July 2023 and only worked for notice for about 7 days. In terms of her contract, she was supposed to work 60-day notice, but she only worked for 7 days. And subsequently, the employer then filed a urgent application at the labor court. The purpose of the application to the labor court was not necessarily to sue for damages, but for an act of specified performance in terms of Section 77, subsection 3 of the Basic Conditions of Employment Act. The reason why the employer wanted her to work a notice period was basically twofold. Number one is to find a suitable replacement, but secondly, they are saying that she was involved in quite important projects, and if she did not do a proper handover, then they would have been at risk of being prejudiced to losing the contracts or pay penalties because they may have been late, and there may have been a lot of reputational damages, and who knows, they could even potentially lose some of their clients. Now, for those of you who don't necessarily know, there are 5 remedies available, really, if an employee fails to adhere to their contract of employment, or if there's a breach or they're repudiating their contract of employment. The one is you can actually sue them at the labor court for a specified performance, and sometimes that will be through the normal application process. It takes a bit of time, 2 to 3 years, to go through the normal order of the court, but occasionally you can apply for an urgent application, like in this case, normally quick. I know they deal with it like every Tuesday and every Thursday. So, but yeah, you can compel the employee to perform in terms of and correct the contractual breach. Secondly, the second remedy that's available is that you can sue an employee for damages. Thirdly, to cancel the agreement. Fourthly, you can actually interdict the employee to compel the employee to perform. And fifthly, a declaration of rights. That's basically a declaratory order in terms of confirming the rights of the complainant. But you see, the thing is, an employee has a constitutional right, or a person has a constitutional right to move freely, but also to exercise their trade. And it is no certain thing that the courts will necessarily grant the act of a specific performance in circumstances where there was actually a breach. Let's just look quickly what the court has said here. They've actually made reference to Farmers Co-op Society versus Berry, where it basically the court are saying that it's not an automatic thing that the court will necessarily grant or award perfect performance, but they will use their discretion naturally based on the circumstances or the merits or the context of the case itself. They have said that prima facie, every party to a binding agreement who is ready to carry out his own obligation under it has a right to demand from the other party, so far as it is possible, a performance of his undertaking in terms of the contract. Take note of that phrase, so far as it is possible to do so, okay? The right of a plaintiff to the specific performance of a contract where the defendant is in a position to do so is beyond all doubt. It is true that courts will exercise a discretion in determining whether or not decrees of specific performance should be made. They will not, of course, be issued where it is impossible for the defendant to comply with them. And there are many cases in which justice between the parties can be fully and conveniently done by an award of damages. So it is not to say that just because there's a breach or the employer is repudiating his or her contract of employment, that it's automatic that the court will grant the act of a specified or specific performance. You have to look at the context and the circumstances, and sometimes some other remedy will be more valuable, like maybe damages, for instance. This was also more confirmed by another case study, Santos Professional Football Club versus Ingersoll. Here the court basically found or explained a bit more detail why it is frowned upon, or generally the courts won't grant or award the performance of a contract. And it basically comes to two reasons. The one is, as we already alluded to, your constitutional right to freedom of movement, your freedom to practice your trade and to exercise your skill. But also, there's a bit of a disapproval when it comes to forced labor. You don't really want to allow a dictum whereby an employer can force employees to actually work for you. In Santos, the court stated, the courts have previously held that the reasons militating against an award for specified performance of a contract of employment were so compelling that they were generally regarded as a rule of law. Interesting. That specific performance of such contracts would never be granted. A very strong statement though, eh? Though it is today not an inflexible rule of law, the compelling consideration why such an order should not be granted remain weighty. Compelling reasons not to enforce specific performance on the part of the employee include a disapproval of forced labor, the fact that damages appear to be significant remedy for an employer, and a similar reluctance to interfere with an employee's right to freely exercise his or skills or profession. So there you have it. They don't want to easily interfere with the right of an employee to exercise their skill in the profession. Bit of a disapproval against forced labor, and obviously, sometimes or more often than not claiming for damages is a better remedy than suing for an act of performance. Okay, but at the end of the day, it is still based on the discretion of the employer, and it is not to say that you cannot sue for an act of performance. But one will really have to look at the prejudice of the employer and weigh that up against the prejudice to the employee and maybe the infringement of her or his constitutional right. So in this case, remember, the employer stated that they will be severely prejudiced because she's heavily invested in contracts and certain projects. If they don't find a replacement and she does not do a proper handover, that there may be a cancellation of the projects. There may be penalties paid. Even some of the projects will probably never actually run to its completion. And that obviously goes without saying the enormous amount of reputational damage that the employer will face. But this is now where the interesting twist came in. The court actually denied the act of a specific performance. So basically the employer in this case actually lost the case for the following reasons. Number one, the employee only worked there for 2 months. She started in May and resigned towards the end of June or the middle of June. She only worked for a very short period of time. And even during this period of time, she was actually on annual leave for 16 days. So she hardly ever worked, okay? Didn't work much. And also, the employee alluded that she was not really invested deeply into any projects, and this was not, strangely though, contested by the employer, and they could not lead any evidence to show that there was any contracts and projects that she was actually heavily vested into. And also interesting is there were other 3 specialists working with her on the same project. So it is not true that if she were not there anymore, that the projects will just came to a natural end. But very interesting is during the court case, the employer actually admitted that they merely wanted her to adhere to her contractual obligations, that even though she may not necessarily perform to required standard, it would still be acceptable for them. You know, that sort of shows that the whole application of the employer was not really a bona fide or a good faith process. I mean, you're afraid on one hand, you know, of the reputational damages, you know, not meeting the performance requirements of your clients, but on the other hand, you're saying you don't mind if she doesn't perform amicably as long as she's just there, you know. Yeah, it's a bit against good faith, but also very telling is the fact that practically she did not only adhere to her contractual duties, there were many other duties which she was, in her view, actually not qualified to do, which she also had to do. So taking all these factors into consideration, and also apparently in the industry it's the norm that this level of employee normally will have to give 60-day notice in the industry. So even if they do find a replacement, that person will also have to give 60-day notice wherever he or she may be. And at the time that person come over, this employee will no longer be there to do the handover anyway. So there you have it. You know, in this case, it's not to say that it's automatic that the employer will actually be granted an award of specified performance in circumstances where an employee may breach or her contractual obligations or contract. What we learn from this is that there are various remedies actually available, and suing for specified performance is not necessarily always the best. It goes against the backdrop of disapproval against forced labor, and probably other than often not, you know, suing for a declaration of rights may be a better option, or damages, or may, in certain circumstances, are supposed to interdict and compel the employee. So yeah, that is all for this week, and please do like and subscribe, and see you guys next week on It's Chaile Time. Thank you.